Michigan Real Estate Team Advertising. Question 1. During a closing preparation in Detroit, a salesperson encounters a rule involving the purpose of a property management employment contract. Which response follows Michigan law, while the file concerns a single-family residence, assigned agency disclosure, and a financing contingency? Option A. Replace all lease agreements. Option B. Transfer title to the property manager. Option C. Create a mortgage lien. Option D. Define the broker's management duties and handling of property funds. The correct answer is option D. Define the broker's management duties and handling of property funds. Property management for another is based on a written employment arrangement. In the described setting, the brokerage should document the step and apply it before moving forward. It does not convey ownership or eliminate contracts with tenants. Question 2. A associate broker is preparing for a team training in Grand Rapids. Which statement correctly addresses the source from which a salesperson may accept brokerage compensation, while the file concerns a small apartment building, an online advertisement proof, and an unrepresented consumer? Option A. Any cooperating salesperson. Option B. A buyer directly without broker involvement. Option C. A home inspector. Option D. The employing real estate broker. The correct answer is option D. The employing real estate broker. Salesperson earnings for regulated activity flow through the employing brokerage. Applied to this scenario, the licensee should follow the rule before creating further obligations for a party. A transaction participant cannot bypass the broker by paying the salesperson directly. Question 3. Which Michigan requirement should control when an employing broker deals with payment of commissions earned before a salesperson left a brokerage during a compliance interview, while the file concerns an office condominium, a listing agreement, and a confidential price limit? Option A. The new broker must collect it first. Option B. The money must be forfeited. Option C. The former broker may pay the income that was earned during employment. Option D. Payment is allowed only after relicensure. The correct answer is option C. The former broker may pay the income that was earned during employment. Compensation already earned under the former employment relationship may still be distributed afterward. For exam purposes, focus on the regulated relationship rather than an informal business custom. A later transfer or licensing change does not automatically cancel earned income. Stressed about your real estate? We can take real estate for you remotely and undetected. We always guarantee a pass in payments only after results. To send us an email, scan the code or tap the link in the description and let's get it done. Question 4. At a lease negotiation, the brokerage discusses the ability to sue for a brokerage commission. Which conclusion is most accurate, while the file concerns a condominium unit, a lease application, and a change of employing broker? Option A. Only the buyer's signature is needed. Option B. An oral advertisement establishes entitlement. Option C. A license is irrelevant in a compensation action. Option D. Licensure must be alleged and proved for the regulated services. The correct answer is option D. Licensure must be alleged and proved for the regulated services. A person seeking judicial recovery for regulated brokerage work must establish lawful licensure. The transaction context changes the facts, but it does not change the underlying licensing duty. Advertising or a participant's signature cannot replace occupational authority. Question 5. A compliance question in Muskegon concerns an additional Michigan place of business maintained by a broker. Which action or statement is appropriate, while the file concerns a retail suite, assigned agency disclosure, and an owner-licensee conflict? Option A. A branch office license is required. Option B. The location is automatically covered forever. Option C. Only an MLS subscription is required. Option D. The salesperson obtains a separate broker license. The correct answer is option A. A branch office license is required. Each additional brokerage location must be connected to an authorized branch office. A written office procedure should produce the same result in comparable transactions. A membership account or salesperson credential does not license the location. Question 6. How should a Michigan property manager handle a situation involving a branch office located more than 25 miles from the nearest boundary of the main office municipality, while the file concerns a manufactured home site, an online advertisement proof, and an expired license issue? Option A. The branch must close permanently. Option B. An associate broker must provide direct supervision at the branch. Option C. No supervision is required. Option D. A customer may supervise the branch. The correct answer is option B. An associate broker must provide direct supervision at the branch. Distance from the main minus office municipality triggers an enhanced branch minus supervision requirement. In the described setting, the brokerage should document the step and apply it before moving forward. Remote availability alone does not satisfy the stated arrangement. Question 7. Which choice best applies the state rule concerning the physical minus location requirement for an individual broker, broker company, or branch office to a buyer consultation, while the file concerns a 2-unit rental, a listing agreement, and a property minus management payment? Option A. Use only a post minus office box anywhere. Option B. Use the address of any salesperson. Option C. Maintain a physical address in Michigan. Option D. Operate without a listed location. The correct answer is option C. Maintain a physical address in Michigan. Brokerage offices must have an identifiable Michigan business location. Applied to this scenario, the licensee should follow the rule before creating further obligations for a party. An unrelated person's address cannot stand in for the licensed office. Question 8. A file from Battle Creek raises an issue about mixing client transaction money with brokerage operating funds. Which answer identifies the governing requirement, while the file concerns a historic residence, a lease application, and a delayed possession term? Option A. A commingling that can lead to discipline. Option B. Required interest allocation. Option C. A permissible commission advance. Option D. A standard marketing practice. The correct answer is option A. Commingling that can lead to discipline. Money belonging to others must be accounted for separately from the firm's own operating cash. For exam purposes, focus on the regulated relationship rather than an informal business custom. A business convenience does not justify blending the accounts. Are you looking for real estate actual questions? Visit our website pokerexams.com to access real estate study guide with actual questions and answers. Scan the QR code or click the link in the description to get real estate answer key today. Question 9. Before completing an open house, which rule should the branch manager apply to using money belonging to a client for the broker's own purpose, while the file concerns a student rental, assigned agency disclosure, and a cooperating brokerage? Option A. A comparative market analysis. Option B. Conversion of entrusted funds. Option C. A disclosure waiver. Option D. A lawful prioration. The correct answer is option B. Conversion of entrusted funds. Personal use of entrusted transaction money is a serious breach of accounting duties. The transaction context changes the facts, but it does not change the underlying licensing duty. Closing calculations and valuation work are unrelated concepts. Question 10. A Michigan exam candidate reviews a scenario involving the handling terms for property management money. Which option reflects the current licensing framework, while the file concerns a vacant commercial parcel, an online advertisement proof, and a rejected counteroffer? Option A is state them in the written property management employment contract. Option B. Let each tenant choose after payment. Option C. Leave them to an oral understanding. Option D. Place them in the deed only. The correct answer is option A. State them in the written property management employment contract. The management agreement must address safekeeping, disbursement, use, and account treatment. A written office procedure should produce the same result in comparable transactions. A deed or tenant preference does not establish the manager's financial duties. Question 11. The broker's policy manual addresses records requested by an authorized department representative during normal business hours. Which provision should it contain, while the file concerns an industrial site, a listing agreement, and an assumed business name? Option A. Require a court judgment in every case. Option B. Provide only advertising photographs. Option C. Destroy the records immediately. Option D. Allow inspection of reasonably necessary documents and records. The correct answer is option D. Allow inspection of reasonably necessary documents and records. The department may examine business records reasonably connected to an investigation or regulatory review. In the described setting, the brokerage should document the step and apply it before moving forward. The inspection authority is broader than a request for promotional materials alone. Question 12. A regulator asks about a licensee selling property in which the licensee has an ownership interest during a brokerage review. Which response demonstrates compliance, while the file concerns a new construction home, a lease application, and a security minus deposit question? Option A. Disclose the ownership interest and licensure in writing before an offer is signed. Option B. Tell only the lender orally. Option C, disclose only after closing. Option D, conceal the interest if the price is fair. The correct answer is option A, disclose the ownership interest and licensure in writing before an offer is signed. A buyer must receive advance written notice when the seller is also a real estate licensee with an interest in the property. Applied to this scenario, the licensee should follow the rule before creating further obligations for a party. Fair pricing does not excuse non-disclosure. Question 13. Which statement would be safest for employing broker to follow when the purpose of a seller property condition disclosure becomes relevant, while the file concerns a mixed-use building, assigned agency disclosure, and a dual- representation concern? Option A, a transfer title to the buyer. Option B, provide the buyer with required information about known property conditions. Option C, replace the buyer's inspection. Option D, guarantee the property will never need repairs. The correct answer is option B, provide the buyer with required information about known property conditions. A statutory condition statement communicates the seller's knowledge about covered aspects of the property. For exam purposes, focus on the regulated relationship rather than an informal business custom. The document neither substitutes for due diligence nor conveys ownership. Question 14. A dispute arises during an advertising campaign over a known material defect that affects a purchaser's decision. Which principle resolves the issue, while the file concerns a cooperative unit, an online advertisement proof, and a protected-class inquiry? Option A, remove it from every transaction file. Option B, hide it until after possession. Option C, communicate the material information as required rather than conceal it. Option D, describe it as confidential pricing data. The correct answer is option C, communicate the material information as required rather than conceal it. Material property information can affect value, safety, or a reasonable buyer's decision. The transaction context changes the facts, but it does not change the underlying licensing duty. Deleting the fact from a file does not remove the underlying duty. Question 15. In Holland, a listing licensee must decide how to proceed with a seller disclosure form compared with a professional inspection. Which decision is consistent with Michigan requirements, while the file concerns a farm parcel, a listing agreement, and a disputed repair credit? Option A, the form guarantees structural soundness. Option B, the form makes all contingencies void. Option C, the form is an appraisal. Option D, the disclosure does not replace an independent inspection. The correct answer is option D, the disclosure does not replace an independent inspection. The seller statement reports knowledge rather than providing a complete technical evaluation. A written office procedure should produce the same result in comparable transactions. Appraisal and contingency rights serve different purposes. Question 16. Which exam answer accurately classifies the rule involving refusing housing-related service because of a protected characteristic, while the file concerns a lakefront cottage, a lease application, and an electronic signature? Option A, a required agency disclosure. Option B, unlawful discrimination. Option C, permitted client screening. Option D, a lawful appraisal adjustment. The correct answer is option B, unlawful discrimination. Housing opportunities must not be restricted on a prohibited discriminatory basis. In the described setting, the brokerage should document the step and apply it before moving forward. Agency paperwork or valuation methods do not justify unequal treatment. Question 17. A new policy is being drafted for directing buyers toward or away from neighborhoods based on protected characteristics. Which language belongs in the policy, while the file concerns a townhouse, assigned agency disclosure, and a referral arrangement? Option A, steering and discriminatory practice. Option B, a neutral market analysis. Option C, a title search. Option D, a lawful zoning variance. The correct answer is option A, steering and discriminatory practice. Neighborhood recommendations cannot be based on the protected composition of residents. Applied to this scenario, the licensee should follow the rule before creating further obligations for a party. Title and zoning work do not authorize discriminatory channeling. Question 18. During team training, the supervising broker tests knowledge of advertising that indicates a preference or limitation based on a protected status. Which answer should the team select, while the file concerns a urban infill property, an online advertisement proof, and a team social-media post? Option A, a lawful deed restriction. Option B, a required broker identifier. Option C, discriminatory advertising. Option D, permitted puffery. The correct answer is option C, discriminatory advertising. Marketing language may not signal that protected people are unwelcome or preferred. For exam purposes, focus on the regulated relationship rather than an informal business custom. Broker identification and ordinary promotional opinion are separate issues. Stressed about your real estate? We can take real estate for you remotely and undetected. We always guarantee a pass and payments only after results. To send us an email, scan the code or tap the link in the description and let's get it done. Question 19. A consumer asks the brokerage to explain reasonable accommodation for a person with a disability. Which explanation reflects Michigan law, while the file concerns a subdivision lot, a listing agreement, and a record inspection request? Option A. Require the person to waive civil rights. Option B. Consider a necessary change to rules or practices unless an applicable defense exists. Option C. Reject every request automatically. Option D. Treat the request as a commission dispute. The correct answer is option B. Consider a necessary change to rules or practices unless an applicable defense exists. Disability protections may require flexibility in policies so a person can use and enjoy housing. The transaction context changes the facts, but it does not change the underlying licensing duty. A brokerage minus fee issue does not resolve an accommodation request. Question 20. Which compliance step is required when the transaction facts involve fraud, deceit, or dishonesty in licensed practice, while the file concerns a rural acreage, a lease application, and a branch minus office distance issue? Option A. Grounds for occupational discipline. Option B. A required form of negotiation. Option C. An automatic contract amendment. Option D. A protected marketing strategy. The correct answer is option A. Grounds for occupational discipline. Dishonest conduct undermines the competence and trust expected of a licensee. A written office procedure should produce the same result in comparable transactions. Negotiation does not authorize intentional deception. Question 21. A salesperson notices a potential problem involving gross negligence or demonstrated incompetence. Which response should occur first, while the file concerns a single minus family residence, assigned agency disclosure, and a financing contingency? Option A. A substitute for continuing education. Option B. An exemption from supervision. Option C. Conduct that can support disciplinary penalties. Option D. A protected advertising style. The correct answer is option C. Conduct that can support disciplinary penalties. Serious carelessness and inability to perform regulated work can trigger professional sanctions. In the described setting, the brokerage should document the step and apply it before moving forward. Education and advertising rules do not convert incompetence into lawful practice. Question 22. The state portion of the exam presents facts about false advertising by a licensee. Which result is supported, while the file concerns a small apartment building, an online advertisement proof, and an unrepresented consumer? Option A. A permitted team slogan in every case. Option B. A method of deed delivery. Option C. A disciplinary violation. Option D. A title minus insurance requirement. The correct answer is option C. A disciplinary violation. Real estate marketing must be truthful and comply with brokerage minus identification rules. Applied to this scenario, the licensee should follow the rule before creating further obligations for a party. Deed and title procedures are unrelated to advertising honesty. Question 23. Which brokerage practice properly addresses helping another person perform regulated brokerage work without a license in the Battle Creek transaction, while the file concerns an office condominium, a listing agreement, and a confidential price limit? Option A. The aiding unlicensed practice. Option B. Lawful delegation to any friend. Option C. A required referral method. Option D. A zoning enforcement function. The correct answer is option A. Aiding unlicensed practice. A licensee may not enable an unlicensed person to perform activities reserved for licensed practitioners. For exam purposes, focus on the regulated relationship rather than an informal business custom. Calling the activity a referral does not change its substance. Question 24. A licensee is comparing 4 procedures related to practicing while a license is suspended, revoked, or lapsed. Which procedure is lawful, while the file concerns a condominium unit, a lease application, and a change of employing broker? Option A. The license remains active for pending deals. Option B. The employer may privately reactivate it. Option C. Only advertising is prohibited. Option D. The person is treated as unlicensed. The correct answer is option D. The person is treated as unlicensed. Authority to practice depends on a current license in good standing. The transaction context changes the facts, but it does not change the underlying licensing duty. Only the department can restore lawful status through the applicable process. Question 25. At the end of a brokerage audit, the parties question failure to comply with a final board or department order. Which statement provides the best guidance, while the file concerns a retail suite, assigned agency disclosure, and an owner-licensee conflict? Option A. A fair-housing exemption. Option B. A separate basis for discipline. Option C. A private contract defense. Option D. An automatic license renewal. The correct answer is option B. A separate basis for discipline. Final regulatory orders are enforceable obligations of the licensee. A written office procedure should produce the same result in comparable transactions. Private transaction terms cannot override the order.